Good Good morning, everybody. It's 8 o'clock this fine Wednesday morning. Very excited to talk to you all today about a case I think you're really going to enjoy because the broker wins. Um, Today we're going to talk about brokers and when they're entitled to their commission on rejected offers. And the case we're talking about is Carmona Realty Group LLC versus Diana Fernandez. So, as typical in these sessions, I'm going to give you a disclaimer because my name is Sam Saad and I am an attorney and I am giving you advice that is not necessarily legal advice. If you have a uh, specific legal need, give me a call separately and we'll set up an attorney-client relationship. So I've been practicing for over 20 years. I serve on the Legal Resources Committee at NABOR, the Florida Bar, Florida Realtor Joint Drafting Committee, and I have a full service law firm that handles cases like this. So we can help you if you're in your commission issues. I also own a title company that closes across the state of Florida. So if you have closing needs, you can reach out to me anytime. Hablamos español. And we're going to dive right into the Carmona case today because I really liked reading this case and I was excited. It's a January 2026 case out of Miami. So it's a new case. Really sets out some good points of law that helps brokers who've worked hard for their customers and have earned that commission, and the seller is just being uncooperative. So let's talk about who's in this case first. Let me give you just a broad overview. Um, Basically, you have Carmona Realty Group LLC, that's the broker, represented Diana Fernandez as the seller. They signed a listing agreement on June 24th, 2017 for a property in Miami. It is listed at $499,500, and there was a commission due was 5%. So it was a typical Florida realtor listing agreement. They had a merger clause that says that this agreement was the entire agreement. It required that modifications be in a written, signed addendum or amendment to the agreement. One thing that stood out in this case that caused a lot of confusion, and we're going to talk about it extensively in this session today, the seller gave separate instructions to agents that only the seller signed, that the broker did not sign, that you're going to hear the seller spent a lot of time claiming that this separate instructions were a part of the listing agreement. And that's going to be a big deal that you need to worry about, especially when we get to the very end. So let's talk more about the case. The broker presented actually eight, 7+ offers, including 4 at a full price and 1 over the listing agreement at $505,000. So the seller rejected all of the offers, citing their desire to raise the price at the time of rejection, and then the timing matters in this case. The seller never objected to any of the other things that we're going to talk about. The seller claimed that they had problems with today. You're going to hear the seller later on talked about the shutters being included, open permits being closed, the amounts of the deposits. None of that was raised by the seller when the listing agent was giving him the 7 offers, actually 8 offers over list. So what happened was the seller just rejected, didn't say anything, didn't do anything. And then when the broker got frustrated and sued for the commission, after the litigation began in depositions, the seller started claiming additional reasons for rejecting the offers. One of the offers, they wanted the shutters removed. One of the offers wanted the permit issues closed. One of them didn't have a deposit that the seller wanted. Another one wanted furniture included. And none of these were mentioned during the listing period. None of them were in the listing agreement terms. So the question is, were they part of the listing agreement? Well, the trial court took into account the seller's instructions, which did have a number of terms in them that in the instructions, like minimum deposit of $1,000 and things like that. The trial court said, well, these instructions were part of the listing agreement, and none of the offers that were received met the terms of the listing agreement when you include the instructions. So the seller was justified in rejecting the offers, and the trial court denied commission to the broker. And obviously, the broker didn't like that. They went up on appeal to the Third District Court of Appeals. That's Miami, South Florida court. And what did they say? Well, the broker argued that the instructions were not part of the listing agreement. He never signed them. The statute of frauds, which you've probably heard of in the context of transfer of property, also includes things that about contracts that have to be in writing for certain things, signed by both parties. And the broker never signed the instructions to agent, which was the title of the document that the seller provided to the agent. The broker also argued that the offer met the terms of the actual listing agreement, and the seller's sole reason for refusing all these offers, that one of which was over list, was wanting a higher price. And you've all had these arguments, I'm sure, with your sellers. I want more money. This isn't enough. And this particular case, these were full priced offers, and the listing agreement, the listing broker was clearly doing their job to get 7 full price offers and 1 over list. So what did the appellate court figure out? Well, one, the instructions to agent document that the seller provided didn't have any consideration, didn't have any signatures on it, and it didn't reference back to the listing agreement. So you think about those things, the consideration. You know, from your contracts class, becoming a realtor, you need offer acceptance and consideration for a contract. There was no money exchange. There was no increased consideration for the agent for dealing with these other issues. The seller didn't lower the price to deal with these issues that they wanted to deal with. So there's no consideration in the agent instructions. The court spent a very little amount of time talking about that. They also talked about the fact that the documents did not cross-reference each other. So normally you would see in an agreement where there's attachments, like an addendum, there would be like a checkbox or written in, see attached instructions to agent. There was none of that in the listing agreement, and there was nothing in the instructions that referenced back to the listing agreement. This is a part of the listing agreement, and then everybody signs. None of that happened. The seller just gave this piece of paper with instructions on it to the agent. Well, the listing agreement that you all use, whether it's NABOR or Florida Realtors, has a merger clause that prohibits oral, unwritten, unsigned modifications. So when you're having these text messages and these conversations with your customer, recognize that if you make a modification, an agreement to change the listing agreement, or the sales contract for that matter, you need to do it in writing, signed by the parties. So the broker needs to sign off. Or if you're an authorized agent to sign for your broker, you need to sign off. The other thing the court found was that the seller's objections were untimely and invalid under Florida law. They were just made up in depositions, that the objections, they were clearly raised by the seller's litigation counsel, not by the seller during or prior to listing or prior to the dispute. And then the court found that the broker produced ready, willing, and able buyers, many of them. And I think that was a very important fact. The broker did their job in this case. So what is the law, in these matters? Well, brokers earn commissions when sellers' wrongful refusal prevents the sale. So if the broker brings a ready, willing, and able buyer, and you've all heard that phrase, and the seller says no, and they don't give a valid reason, then they're going to owe a commission. If you're going to have documents that are separate from each other, they need to be signed writings and or referenced to one another. And then the statute of frauds requires signatures. So make sure documents are signed. Let's talk a little bit about procuring cause in this case. Where a broker procures a customer ready, willing, able to purchase property offered for sale according to the terms of the offer, and the transaction is defeated on the account of some fault of the principal, that's the seller in this case, the broker is entitled to his commission even if the transaction is not consummated. And why am I bringing up this obvious principle of law that we all know? Look at the date of this Hutchins versus Sherman case, Hutchins and Company versus Sherman, 1921. So the court didn't make stuff up. This is old law. Brokers have always been entitled to commissions where sellers were screwy. And I think it's important. I think the reason I really want to talk about this is I hear a lot of agents call me, Sam, I'm not getting paid. Sam, they want to reduce the commission. Sam, this, that, and the other thing. And I tell brokers and realtors, you got to fight for your rights. You guys do a lot of hard work, and it's not recognized. So the court also talked about the merger of the documents. I mentioned this. Two instruments signed by the same party concerning the same matter and signed and or about the same time can be merged into one agreement in this quick snacks case. But what they said is it's got to meet a whole series of tests. It's got to be signed at the same time. It's got to be about the same thing. It's got to have at least reference each other. And we talked about the statute of frauds. The broker never signed the instructions, and then the listing agreement contained that merger and integration clause. So the court ultimately held that the trial court got it wrong. The Third District Court of Appeals ultimately said the trial court was wrong to rely on the instructions document, that the offers met the listing agreement terms, and that the broker was entitled to their commission, $25,250 on the highest offer rejected. So all this for $25,000. And we're going to talk about that in a second. But just as a conclusion to the case, listing agreements control all the terms. Seller breached by refusing these qualified offers. And so the court reversed and sent it back to the trial court for award of commission fees and costs. So the broker is going to get their money. They're going to get their $25,000. They're going to get their attorney's fees paid, and they're going to get their court costs paid. But at what cost? This case took 9 years, and it's not over yet. This is a 10-year ordeal over $25,000 because they just won in January at the appellate court. They got to go back to the trial court. They got to get a new trial date or hearing date. They have to get all the documents pay all the copy costs to bring the appellate record back to the trial court, get in that hearing, get their fees, and then they got to collect. I mean, it's been 9 years. This property's probably been sold. Where Fernandez is and where her money is now a question. So let's talk about some lessons learned, some practical takeaways. They really, I think, are going to help you not go through this process that this poor Carmona Realty had to go through. First of all, your listing agreement is your protection. So make sure it's complete. Make sure the blanks are filled in. Carmona won because the listing agreement stated the price, the commission, and the broker earns the fee if the seller refuses the offers that conform to it. And everything should be in that one document. Don't have separate unsigned papers, emails, text messages. Text messages don't even count. The courts throw them out, and the agreements now say you're not supposed to text. The other thing is, I didn't mention this, the instructions to agent, part of it was actually drafted by Carmona. So don't give your seller instructions or talk to them about the instructions that they might want that are not part of the listing agreement. If a seller has additional requirements for how offers to be presented, they should be put in writing or an assigned addendum, not a separate sheet that only the seller signs. So be very careful. And we're going to talk because there's a statute in Florida that I think some of you know about under Chapter 475 for instructions. We'll talk about it at the end. But the other thing is document the seller's stated reason for rejection in real time. If the seller calls you up and says, I'm not taking this offer because I don't want to have to take the shutters down, send them an email, copy your broker. Hey, I just sent you a full price offer. I understand you don't want to take the shutters down. However, that's not in the listing agreement. Please reconsider. You know, warn sellers upfront about their obligation to cooperate. Fernandez, in deposition and at trial, the seller said she never read the listing agreement beyond looking at the sale price, the listing price, and the commission amount. She didn't realize that she had all these obligations to conform and comply and sell the property. So again, trying to prevent 9 years of court costs and fees to lawyers, walk your seller through the listing agreement. Walk your buyer through the sales contract. This is what you have to do. This is where your obligations to me are. This is where your obligations are, to other parties. And it helps if you really understand the listing agreement. And if I can give myself a shameless plug, go to my YouTube channel and watch my presentations on the other agreements, listing and contracts. Last thing I'll say here is know your rights, that you earn the commission even if the sale doesn't close. And the seller should know that. So when they sign the contract, they say, if I bring you a ready, willing, and able buyer, I'm going to earn my commission. And it's long-standing Florida law. And then Fernandez claimed Carmona told her she could raise the price whenever she wanted. It was never an assigned amendment. So things must be in writing. I'll give you one last thought on Chapter 475, and then we'll take questions. The broker statute, Chapter 475, has requirements that a realtor must present all offers, counter offers in a timely manner unless a party is previously directed the licensee otherwise in writing. And Florida Realtors kind of summarizes this, that unless your buyer or seller sent you something in writing in advance, you must present all offers. However, some practical thoughts about this statute, because it's ironic to me that this statute was never mentioned in the case, because the seller gave instructions under Chapter 475, but the listing agent never signed them. So it's funny to me but this statute was never mentioned. As a practical matter, the seller can give instructions about offering below a certain price, rejecting offers with finance contingencies, rejecting offers not on particular forms, rejecting offers requiring closing timelines. But absent a written offer instructions, the listing agent must present every offer. In this case, the listing agent did present every offer, but the offer didn't meet the terms of these special non-contractual instructions. And with that, questions? Nobody has any questions? You can unmute yourself. Really? Cassandra, you must have a question. This is my sister-in-law's on our own webinar. All right, if there are none, I really appreciate everybody coming in today. I knew this was going to be a short one. If you do, hold on, we do have questions coming in. Wait, Crystal is asking, do we have to present oral offers? No. If someone calls you up and says, I'm willing to pay X for a property, your reply back to them is put it in writing. The statute of frauds requires a writing. Linda, you're asking, is email okay? Does everyone have to sign? That's a very good and fact-based question, Linda. If you receive an email from a seller and it says, hey, I don't want to see an offer that makes me take the shutters down or close the open permits, and you reply back to them and say, okay, no problem, I think you might have a contract. You might have an amendment to the listing agreement, I should say. But if you reply back to them and say, I'll send you something, I'll send you an amendment, then you are in a much better position. Aaron, you're asking, did you say texts won't hold up in court? Aaron, the court routinely looks at texts in a very negative light, and at least the neighbor agreements say no texting. Texting is not official notice. So you have to send an email or do a signed writing like you were talking about. Other questions? Nobody? I'm going to see if anybody's entering in the chat. Oh, Michael is saying, I have a seller who has a price offer floor. Should I get that in an addendum? That would be a perfect example, Michael, of putting something in the listing agreement that says you don't have to present offers to the seller that are below a certain floor. Yes, I would have that in an addendum to the listing agreement. And you can use e-sign, Crystal. Yes, e-sign is valid under Florida and federal law for almost everything, except for things that have to be notarized in person with witnesses. Then you have special requirements. But you can use e-sign for almost everything. Other questions? Yes, Marianne, you can add it to the contract. Instead of having an addendum to the listing agreement, you can add it to the contract. All right. Well, if you want to unmute yourself, you can. You can always email me or call me later. But thank you everyone for coming today, and I'll have another one out soon. Talk to you soon.